that the investigation is of the prime importance in a trial of the case. It is the foundation on which the whole case rests and resolves. Lack of expertise and sustained efforts in investigation and non-utilization of specific method or scientific method of investigation present a skewed picture. Thereby harnessing the entire process, the officers of the companies as well as the associate professions are often being called upon to give statement, information, or explanation to the enforcement agencies such as SFIO, SEBI, tax authorities, ED, CBI in the course of inquiry, investigation, or search. The officers of the company or the associated professionals are often in the dilemma about their duties as well as their rights, and in spite of best intention. It is therefore pertinent to know the kind of appropriate conduct in order to face the situation with confidence and sanctity. To strike the balance between the needs of the law enforcement on the one hand and the protection of the citizen from oppression and injustice at the hands of the law enforcement machinery on the other is a perennial problem of statecraft. The objective of webinar is to address questions about right and duties of summoned person as well as that of the officers concerned, and also how to articulate statement and compile information or document so as to serve the law in the best possible manner, and also to address apprehensions. India being a country ensuring equitable and fair justice to its people, it is pertinent to ensure that such fairness is not limited to the trial, but rather brought into the investigation as well. The same can be only assured through application of various specific things and in fair and just manner throughout the process. Today, we have an eminent speaker for today's webinar. We have Mr. Amit Khemka, Advocate Supreme Court of India. He has experience of more than 35 years in various courts, civil and criminal proceedings, working in various law, PMLA, criminal laws, handling SEBI, CBI, ED, and the court matters also. I welcome Amit Khemka ji for today's program, and I hope that your experience will bring laurels for the people who have joined today and they want to get some nitty-gritty of this subject. Then we have Mr. Ashwini Taneja, who is advocate, RRA legal, an ex-member of ITAT. He is expert in PMLA and Benami law, and he has a vast experience of handling the income tax raid and seizure, search and seizure, and he has delivered more than 2,000 judgments in his short stint when he was appellate tribunal member. I welcome Ashwini ji for your expert view from both the side, this side and the other side, and now representing to the corporate and the professionals. I welcome you.
Thank you, sir. Thank you.
Then we have Mr. Ravi Prakash, Associate Partner, Securities Law and Corporate Litigation, Corporate Profession. He is handling matters relating to company law and SEBI law, and he has experience of handling various investigation and representing before SEBI. Friends, as you are aware, that today's program is very important for all of us as a professional, as a corporate. You know, when you do business, this is an occupational hazard that investigation agencies can ask any question. They are here to protect the interest of the other stakeholders also, and sometimes knowingly or unknowingly you have done something which has a far-reaching consequences. So sometimes people think that he's innocent, but other side knows the law, and sometimes we have faced that this particular law gives power to authorities. So sometimes absolute power makes them a different person altogether, and they missed out the certain fair and just equitable justice. So today we want to discuss all issues. What is happening? Sometimes some notice is coming and the people are objecting that how they can send. So we have to understand the right and duties also of the accused, of the person who has received notice, who has to appear before the authorities, because there should not be any confusion that this question they cannot ask. Why should I give this answer? So today we will discuss all facets of this. So the program structure will be like this, that we will have this entire structure on question answer based. So we have prepared question answer questions and the respective speaker will give answer. So I'm starting with Amit Khemkaji. Sir, as you are aware that today we are discussing on Companies Act, Securities Law, PMLA, Benami Law, Income Tax, and various other tax. And we are discussing about the role of SFIO, Regional Director of Companies Act. They are doing investigation, SEBI, ED, which is handling the PMLA and other matters, income tax authorities, like income tax people can come and search, and various other agencies which are there. Then we have a CBI, we have the economic offense wing. So all these people are there, all these agencies are there, but common parlance are not much different. The basic concept of how they can call for the investigation, how they can call for giving a summon, how you have to go and reply. They can record your statement, and after the statement, if they find that you are guilty, they can put your name in the charge sheet, and then you have to defend it in the court of law. And in the court of law, you have so many issues that your statement which you have given to before this authority, what value it has, whether it is valuable or not, the court accept this or not, because sometimes people have a confusion that the statement recorded before the police is not admissible. You have to prove. Who has a burden of proof? It is always authority, or in some law, it is on the burden of proof is on the accused side. So we want to discuss all these issues because common issues are there. So you have handled so many cases. You have handled so many criminal jurisprudence issues you have come across. We want to understand that what are the provisions with regard to investigation by various agencies under these law. So we can kick start, and then I will ask Ashwini Tanejaji, what are the provisions regarding search and seizure under these laws. So over to you, Amitji. You can give a brief starting on these subjects.
Thank you, Pavanji. Thank you, Ashwini-ji. Thank you, Ravi-ji. And thanks to all the members and all the professionals who've taken out time to be part of these deliberations. See, the basic is that whenever a wrong is done or is alleged, the investigation has to start. Now, what is the purpose of investigation? The purpose of investigation is collection of evidence. We all know that evidence could be oral, evidence could be documentary, evidence could be in certain articles, in the shape of certain articles or things. So the primary purpose the investigating agencies have been given powers is for the collection of evidence to prove that the alleged wrong has been done, or to come to the conclusion after investigation that there is not sufficient material or sufficient evidence to come to the conclusion that any wrong has been committed. For that, it is common knowledge that any white-collar crime or any white-collar offense would be done behind closed doors. It would be hedged, the conspiracies would be hedged behind closed doors. It won't be easy to recover or collect the evidence of such wrongs. And therefore, some powers, as in some cases we might even say draconian or excessive, have been bestowed upon the agencies, though with the hope that they will use them in an equitable manner, in a fair manner, in a just manner. These powers include the powers to summon documents or any other kind of evidence. It includes power to record statements. It also includes the power to search any premises. And in the end, it includes the powers of custodial interrogation. Some of the laws which you mentioned do contain powers of arrest for the purpose of custodial interrogation, but others don't. For example, now when CBI is the investigating agency, let me tell you that there are certain judgments of certain high courts which have been stayed by the Supreme Court, and the matter is pending in the Supreme Court of India, whether CBI is a legal investigating agency or not. Because CBI was established under the Delhi Police Establishment Act, and there is a big question mark on its entitlement to investigate, on its legality itself. However, as on date, it is a legal agency. It has the powers under the CRPC to investigate all the matters. It is considered as police under the normal law. As you have state police, the CBI officials are also considered as police officers. Then we have Enforcement Directorate. Then we have SFIO, the Serious Fraud Investigation Office, under the Companies Act, New Companies Act, and then you have income tax authorities under the Income Tax Act, or investigating under the provisions of Black Money Act or Benami Prohibition, PBPT, as we say now, the new act, and ED investigating under FERA or under PML. FEMA, I'm sorry, not FEMA, FEMA. So these are different acts under which these agencies have been granted powers to investigate. Except for CBI, none of these authorities or none of these investigating agencies are treated as police officers. We may have our own views, we may have mark of questioning on that, but however, that is how the law held by the Supreme Court as it stands. Now, there are no powers of arrest under Income Tax Act or PBPT or the Black Money Act. There are no powers under even FEMA. However, there are powers of arrest under the PMLA, under the CRPC. There are powers of arrest under Companies Act. SFIO has the powers of arrest. So these are the general powers. As I said, the power to summon documents, power to summon evidence, articles, power to summon and take statements, power to search. They are almost available to all the agencies. However, it is only the power of arrest or custodial interrogation, if we may say so, preventive detention, is only with the SFIO, ED, and the police So is with the CBI. So these are this is the general situation. As we go ahead, we will deliberate on each one of these powers at a little bit length. Thank you, Pawan.
Okay. So, Amitji, you have mentioned and started in giving a clear direction that the closed door conspiracy require some draconian and excessive power. But simultaneously, this is also very important. These two powers sometimes should not be misused. It is a very fine balance you have to do. And these authorities, sometimes they do, sometimes it is missing. So let's understand, Ashwini also, that the arrest power and other things which Amitji has told, what are the provisions regarding search and seizure under these laws? Because they can call for statement, they can call for someone, they can ask document, they can search also. So to get the information, so what are the search and seizure power under these laws and the provisions? And what are the do's and don'ts for the both the side? We should, as a authority is coming, so you should be aware that you have to do this, and simultaneously you have to protect yourself from this. Over to you, Ashwini. You have to unmute, please.
Thank you, Pawan sir, for organizing this seminar actually on the topic, which is not only very hot, but also this whole topic is very close to our heart, because day in, day out, we are facing such situations where, on the one hand, investigation agencies are grappling with the zeal to collect as much evidence as possible. On the other hand, the people are also struggling to face the situations. They are stuck because on the one hand, they have to be fully legally compliant. And on the other hand, they also do not want to be damaged in a manner which is not properly lawful or unfair to them. So, I mean, from both sides, there is a situation of tightrope walking. So anyways, your question can be divided into many parts, and I think I will take only 2 parts as of now, because there are many other questions to come, and Khemka sir is also there. So the entire question cannot be answered in one go. As we'll gradually progress, we will make an attempt to answer all the facets of the question you have put forth. But first of all, what kind of powers are available under different laws dealing with economic offenses with respect to search and seizure? So there are, these economic laws can be divided basically in these 4 or 5 categories. Like we have Income Tax Act, we have Black Money Act, we have Prohibition of Benami Property Transaction Act, we have FEMA, we have Prevention of Money Laundering Act. So these first 3 laws are regulated by Income Tax Department, as you know, and enforced by the Income Tax Department, such as Income Tax Act. So Income Tax Act contains power of search, survey, seizure, etc. 133A gives power of survey. Section 132 gives power with regard to search and seizure. So Income Tax Department has been clothed with sufficient powers and wherewithal and entire infrastructure to carry out searches and surveys throughout the country. As the department, the offices of the department are located, they are widely scattered all over the country. Then as far as Prohibition of Benami Property Transaction Act and Benami and then Black Money Law is concerned, there are no powers under these laws. But that does not come in their way, because ultimately this is being enforced. Both these legislations are being enforced by the Income Tax Department only. So searches are conducted by the income tax officers only, under the income tax law only. But whatever material is gathered, that is of course shared with the departments enforcing these laws, that is Black Money Act and Prohibition of Benami Property Transaction Act. So that is how under 3 legislations, powers with regard to searches are carried out. Now, as far as PMLA and FEMA is concerned, you know that it is, everybody knows that this is, the enforcement is led by the Enforcement Directorate. So both the legislations contains power with regard to search and seizure. Section 17-18 of PMLA gives power to carry out search, and similarly Section 37 of FEMA gives out power of search under FEMA. Now, with regard to other laws, there are many laws and we can keep on going. GST also has power of search. NDPS also power of search. Customs has also power of search. So most of the legislations contain power of search. So other than these two, Benami and PBPT, Benami and Black Money Act, I mean, most of the legislation contain powers of search. And for this, the obvious reason is because their mother legislation or the department has power of search under mother legislation. That is why probably the no need was felt. Though they could have added few more sections for giving power of search there also, but I could not get the answer. They could have also been given separate powers of search. But anyways, this is the situation. And your next question was with regard to what is the rationale, probably, for giving such draconian and wide powers, infringing upon the privacy of the citizen of the country under these laws. Because time and again, our constitution has upheld the rights of privacy. So why these powers? Now, the answer is simple, and some portion of which was touched by Khemka-ji few minutes back, that there would be a situation where the investigation agencies would not be able to gather the evidence by the routine exercise of issuing summons or routine recording of statements. So if a person is issued with the notice or summon for recording of statement or providing of certain documents, so if the reasons to believe are such that in response to recording of summon, in response to the summon for recording of statement or calling for some documents, the requisite information or the documents will not be provided by the noticee, then the department can exercise its power of search. Similarly, under PMLA, if there are reasons to believe that so-and-so person has done the offense of money laundering and is in the possession of proceeds of crime, which can be concealed, transferred, and such kind of information, of course, will not be shared by that person with the enforcement directorate in response to summon or notice or recording of statement of section 50, then in that case, search can be carried out. So these are the broad purposes under the laws where the powers of search are exercised. In simple words, when the department cannot gather the evidence in routine manner, then it gathers the evidence by way of carrying out of search and surveys. Thank you, Pawan.
Okay. Amitji, now Achiniji has told and given the reason, and you also have told the rationale that these are the crime which is done in the closed door and in so many layers. So you require some power. Now, what are the provision granting power with regard to arrest or detention or custodial interdiction under these laws? Amitji.
Sir, before I come to the arrest or other provisions, I would first like to address as to what a person is supposed to do when he is faced with a search. After all, what are his rights? How he is supposed to face, how he is supposed to behave. A large team of officers is at somebody's doorstep. Maybe in the morning at 6 o'clock, maybe in the midst of his business, when his business is going on, maybe at any given time or at any given moment. He may have ladies in his house. He may have, the guests in the house. The name itself is very scary. And it becomes more scary with the way sometimes the agencies behave. So how we are supposed to, how a person of common prudence, how a person who is faced with such a situation is supposed to behave? I would say keeping calm is the first requirement. They have just come to perform their duty. That should be the way we need to understand and need to behave, need to react. So we should be very respectful to all these people. Even before asking for a copy of the search warrant, we should say, sir, kindly wait for a moment. I am getting some water for you people. And thereafter, you must ask them, can I see the copy of the search warrant? One needs to check whether the search warrant is actually for one's premises also or not, whether it is in that person's name also or not. It is necessary. We recently had a case where a search warrant of some other entity and some other place was used to barge into one of our clients' place. So you have to very respectfully ask them for the search warrant. You should very coolly and carefully go through the contents of that search warrant. And if it is not for your place or your premises, then to respectfully tell them that, sir, this is not for my place. Then you are also entitled to ask for the identification. Take an example that somebody, some miscreant comes to your premises in wearing uniform or not wearing uniform or having a fabricated search warrant. So you, in all fairness, the person is entitled to look for the identities of the people who are searching, who have come there. So, and for that, there is no harm. It should be very courteous. At the same time, it should be firm. This is your right. This is for your safety. This is for the safety of your family and your business. One is also entitled to make personal search of the people who are coming into your premises. Because, for example, somebody wants to plant, suppose it's a mischievous search, or there is an intention of planting. So the law authorizes the person being searched or whose premises is being searched to search, to take a body search, to take a personal search of all the officers who are entering your premises. Then one of the major factors are the panchas, but we call them panchas or witnesses or independent witnesses, whatever name you give. All these searches under the law have to take place in presence of independent witnesses. There is a practice with all these agencies that they bring witnesses with them, which is not only, I would say, illegal, but also this practice needs to be condemned. Because the law requires that these should be the people who are incidentally at the place. The people of the locality, people who are present there, to happen to be present. So, whoever they are claiming to be the punch witnesses, you can ask them that, sir, how are you here? How could you be present here? What are you doing here? Because we have cases where the search was taking place at 6 o'clock in the morning. The witness lived almost about 40 kilometers away. So how was it possible? That means that witness is a stock witness. He's a witness who has come at the instance of the agency. So you can very well refuse to allow that witness to take part in the proceedings. And you may ask that, sir, somebody from the locality must be enlisted as a witness. We have a neighborhood where respectable people do their business or they live. So you call anybody from the neighborhood or anybody who is who can read or write, anybody who is there around. So these witnesses need to be what we call as punch witnesses, or what we call as witnesses of the Panchnama or witnesses of the Caesar memo. Because this Panchnama has many names, the Panchnama, the Caesar memo, and all those kind of names. So whatever in fact, in this Panchnama, they make out a minutes. So it is sometimes it is not even a Caesar memo, it is the description of what transpired. So it is a little more than or little different than the mere Caesar memo. However, it contains whatever was seized also, the goods, the list of seized goods as well, or seized documents. So one is entitled, my friends, to object to these witnesses who are, in our legal language, we call them as stock witnesses. They are the witnesses which the agencies have, and those witnesses who are not going to be independent, who are under the influence of the agencies. What they have been doing, they bring some bank officers or government officers with them, which is no guarantee that these witnesses would be fair, or these witnesses are not under the influence of the officers, or they are not personal friends of some of the team members. So therefore the law provides that one should be, whatever is the witness should be incidentally there. They need to be happen to be there. Then if your place has CCTV cameras, they have no right to switch off those CCTV cameras. Those CCTV cameras need to continue recording. If they do anything like that, if they try to barge in forcibly, or they try to switch off your video cameras or CCTV cameras or something, then in that case, one must immediately call at 100 number. You must record your complaint at police control room. And why we say 100 number? Because police control room keeps a log. So your complaint, even if there is no action by the police under the influence of that particular agency, your complaint will stand logged. It cannot be removed from there. It will remain as evidence of the fact that you had objected to the illegal actions at the time of the raid, which may render the complete search as illegal. Then they are not supposed to cause hindrance in your day-to-day working. Like, for example, taking bath, eating, worshipping, children going to school. All these things will go on normally. They don't have any right to stop the college going or school going students from not going there. They may, in fact, it is not arrest. However, normally what they do is that they close the complete movement. So that sometimes can be objected to. However, normally, to my mind, there is a question mark on it, whether they can stop anybody from going out and coming in. Because what they can do is that they may take a personal search of a person who is going out, or they may take a personal search of a person who is coming in, because they don't have any right to unless they say that we are arresting a person, they cannot detain anybody. Then they have to give time to Parda Nashin woman to withdraw from the place and take their own sweet time for suppose their statement is to be taken. So whatever are the norms of Parda Nashin woman. Then if the premises has woman, and if they intend to search the premises, there should be some woman police officers accompanying that team, because no personal search of a lady or a woman can be taken by a male. So that would again be a illegal act. That would again be violating the personal rights. Then you are entitled, suppose they are searching your wardrobe, you are entitled to be present at the time of that particular search. So one has to request that, sir, if you are 10 people and I am 1, so you cannot keep on going into 10 rooms. You ought to allow me, whenever you are going into a particular room or particular place, you ought to allow me that I am there. It is not possible that you are searching something in my absence. So, and that ought to come in the Panchanama as well later on. So, these are some of the things which come to my mind, which one has to, you must be courteous to them also at the same time. You must arrange for their food if it is possible. You must arrange for tea, coffee, normal water. As you do to any guest, you should not have inimical attitude towards them. You should not consider them as your enemies in the first place. You have your rights, you must exert your rights. But at the same time, there should not be any conflicting attitude towards these people. So these are few things which we can readily say. As other questions will come, we would love to answer those.
Amitji, there is one issue.
Yeah.
That sometime when you search,
Yes,
these officers, you are under influence or you are under fear, you are sometimes forget your basic rights also.
yes.
So, and then it comes against you. And second is sometimes when they search and they are doing something which is your personal in nature, maybe secret in personal nature, your personal life and other thing, how much right they have to touch your personal right or some other thing which is not connected with the case. But officer can say, no, this is suppose they are coming for something and you have your girlfriend, their paper, other things are there, and they want to see this, and they can tell, no, I want to see who is this, because that may be a connection. So what are the rights people have?
I think Shuniji wants to come in. When you...
Ashwini, can you just tell us?
Sorry.
And,
In fact, this question can be divided into 2 parts, what you said. First of all, if they find any other material which may be purely of personal nature, that is category A, which has got nothing to do with the object of the law under which search is being carried out. Second category could be that there is some material which may not be under relevance of the particular law, but may be of good relevance under other allied laws. Now, as far as first category is concerned, which is purely personal in nature, nothing to do at all, even in far-fetched imaginations, I think every officer, there is a good human being. Let us presume he is doing his duty. There are some certain very personal, intimate issues connected with the person being searched. And I have not seen any officer coming across that where he becomes hellbent, I will bring it part of the search seized material, or I will make it public. I have not seen it coming across. Unless some inimical actions have happened over there on both the sides. So that is where Amitji concluded. I think I am thankful to Amitji, because Amit sir has very rightly concluded, and there lies the entire solution to the various problems which are unnecessarily purchased by both the sides. That though rights have to be protected on both the sides, but there is no need to be inimical. There no need to be discourteous. There has to be a basic sense of hospitality as is extended to any guest, even if the guest is unwanted. So that is to be taken care of mind. Only then that person will return and reciprocate in this manner that he will not touch the personal things. It purely personal things. Now let us come to the second part. The second part is very, very important, which is troubling a lot. That say search is happening under income tax law. Nothing is there with regard to the tax evasion. But there are certain things which may show that elements of money laundering or Black Money Act or FEMA or maybe many more such things.
Any other criminal activity? Any other?
Maybe any other criminal activity.
Maybe revolver at your place.
Yes.
Yes.
Narcotics
That is
revolver.
really a mind-boggling situation. What should be done? Even the officers come in a dilemma. What should they do? Because why they are in dilemma? That the law expects them to report it. For example, under Benami law, it is clearly mentioned that every officer, there is a long list of officers, that if we come to the notice of any Benami transaction, it is his duty to report to the BPU. So on the other one hand, law expects him to do this. On the other hand, his officers are saying, his seniors are saying, please focus on your business. Otherwise, our focus will get scattered. So before I come in dilemma as a such person, even that officer is also in dilemma that what to do. So, I mean, this is a situation which varies case to case basis, but legally speaking, it is his duty to report if any illegal activities, prima facie illegal activities or documents related to are found, or at least make it part of seizure and such and such. But you must have noticed, you must have read it in the newspaper, it has happened that in the case of a search, now there were details found with regard to transactions happening with certain officers, unscrupulous transactions recorded in diary and all that, or some political people, or some big people of the country. So in some cases, they were made part of the seized material. In some cases, it was revealed later on, or it was learned, or it was in the air, or whatever you may say, rumor that no, they were removed. So these things remain again subjective, again varies case to case, and nothing, no concrete, words can be said about it as far as this situation is concerned.
There is a third category which I would like to add.
Yes.
Sir. That is a third party property.
Yes. Very important.
Which is very important in the case of professionals.
Yes.
Now, a professional is being searched for a particular case in which he was involved, maybe in the professional capacity. Maybe, for example, the client says, my originals are lying with my chartered accountant, or they are lying with my company secretary, or they are lying with my lawyer. So the premises is being searched only with a very targeted motive that the evidence belonging to that particular case is required to be collected. However, when the agency comes, it says, we are going to seize your complete hard disk. We want your complete email box. Now, this may contain third-party information. This may contain my privileged information of my clients. Now, what to do? So, as Ashwini said, that the first key lies in being decent and courteous. If you have not generated any kind of hostile atmosphere, the agencies are, in 99% cases, they are likely to cooperate with you. They would say, okay, sir, give us the information which is relevant to us. We will not touch the other information. Suppose they still don't agree. Then in that case, I would say that the best thing is to ask them to seal, ask them to protect it till you are able to approach the court. You may say that, okay, if you are not agreeing with me, fine. You may seal my computer. You may seal my hard disk. You may seal my gadgets, or even the records which you want. You may seal them. You may seal my office because I want to go to the court, and I want to have an order of the court. Unfortunately, our courts have refused to lay down guidelines on that. Most of us must be knowing the case of Mahmood Pracha advocate. The search was, in fact, the search warrant in that case was a very pointed search warrant. It said that this is what is the case, only for this particular purpose, the information is required. Still, they wanted to seize the whole of the hard disk. Mr. Pracha advocate had to approach the court. The court granted him relief, that only that portion which was relevant should be taken. However, unfortunately, when he went to the High Court for laying down the guidelines, the High Court said that no, we cannot lay down the guidelines. We will presume that the officers in most cases will act fairly. So the responsibility that the officers act fairly, as I said, lies upon us as well. If I was to ask to see the warrant, or to ask for a copy of the warrant, I would say, sir, आजकल जमाना थोड़ा खराब है. Anybody can come. कोई भी आदमी किसी भी भेष में आ सकता है, sir. Can I see the search warrant? I will start from here. I'll say, sir, if you don't mind, sir, can I see your ID cards? The other way could be, you have to show me the search warrant. You have to show me your ID cards. You cannot go there. You cannot move like this. So it is upon you how you make the atmosphere cool and calm. So it all ultimately will revolve upon the subjectivity of the team. And you, of course, have that right. I told you, you can call 100 number in case of, if in case they are not behaving properly, in spite of you being nice. If they are not behaving properly, you can ask that, okay, you seal my office, you seal my house. I'm going to go to the court. And then let the court decide in the meantime. So this is how we have to handle these searches. And we can go to the next question now.
Okay. Ashwini-ji, this question pertain to all these laws. You can give answer in one. Whether the search person is entitled to copy of search warrant and the Panchanama, it's please tell us about income tax, ED, CBI, or others.
Two parts, and both I will do separately, touch upon separately. First of all, warrant. Now, it has already been conveyed by Khemka sir very aptly that we must see the search warrant. My understanding is that I can demand copy of search warrant also. But there is no clarity under the law whether I am entitled for the copy of the warrant and whether they must provide the copy of the warrant. Rather, if there is some clarity, it is a negative. If at all there is some clarity, that no, I am not entitled for the copy of search warrant, which I am not able to digest. I can understand if I demand for satisfaction and this is not being given at the preliminary stage of investigation or search because of various reasons like security, confidentiality and all that. But as far as copy of warrant is concerned, I think that must be given straight away. But I am shown the copy, I am not shown the copy in those tense moments. What could I see, what I could not see? I mean, this is the basic statutory duty of any person who is, any officer who is invading the privacy of the citizen of this country. The copy must be provided. Now, as far as your second question, it applies in all the laws, whether it is under PMLA or under Income Tax Act. As far as the copy of Panchanama is concerned, that is the statutory duty as well as my right to have copy of a Panchnama.
Okay.
A search cannot
Okay.
be concluded without a valid Panchnama, having been drawn and having been delivered.
Okay. Amit ji,
Yes, sir.
as you are aware, when there is a search and seizure, then these people record the statement. And this is happening every time. So in all these laws, so first you can give answer, then Ashriji can answer. Whether you can take a statement on record, and then I will ask Ravi also that you can also tell in the SEBI and Companies Act SFIO what are the entitlement of the statement recorded, whether I can get a copy or not. Amit ji.
Sir,
I'm intervening in between. I'm sorry. One important facet was left to be touched, in which I would invite the attention of Khemka sir also. Recording of a or drawing of the Panchnama in appropriate manner, as the law expects. That is a topic which everybody must know about it a little bit, because I have seen disastrous consequences of an invalid Panchnama on both sides. The search will also collapse, the objective will not be met, it causing damage to the investigation agency. Other side also, the something for which no consequences should be faced by the such person, he will have to face the consequences because of searchnama not being drawn in accordance with law and facts of the case. So on that, I will speak 2-3 lines, and then I will invite attention of Khemkaji if you would like to add anything. Pawanji, I hope you will permit me to.
Yes, carry on.
Now, Panchnama records a factual situation of search, how the entire action has been carried out, and what are the findings, factual findings, and the material recovered. So few things which are very important are that the Panchnama should draw a correct picture of the situation, not an incorrect or invalid or twisted or distorted, and complete. It should not be incomplete also. For example, what time search began? Who were the officers who carried the search? What were the premises? What time search was carried out? When it was concluded? Whether personal search was offered or not? Whether personal search was taken or declined? Now, for example, in one case, what happened? The moment they entered near the search premises, the search team, it was case of a diamond company. It was seen in the CCTV that they were carrying backpacks. So carrying the backpacks, entering into the diamond company, who was dealing in the trading of diamonds, and not offering to search, and immediately thereafter it was seen that they went in the server room and switched off all the cameras. Up to this extent, recording was available, because it was being saved on iCloud, though they had removed the server and everything, but it was being saved on the iCloud also simultaneously. Now, this fact invalidates the search. So, whether personal search was offered or not, whether declined or not, very, very important. Then, place of recovery. Suppose that the place of search is very big. It's a big residential house. There are joint families living. There are, say, 10 rooms. Now, it has become practice when the Panchnama is being drawn by the enforcement directorate that they will total up the entire cash, say 25 lakh, 30 lakh, 100 lakhs, whatever is found during the course of search in a business premises or in a factory premises, and they will simply mention the total. Okay, 90 lakh rupees recovered. Now, if search person is in the name of one person, warrant is in the name of one person, search is being carried out upon many persons because being living jointly, it is absolutely unjustified and unfair to total up and mention the recovery from one person. You can make recovery, you can seize also, but you must bring out the fact fairly that this much cash from the room of this person, this much from this person, this much from this person, this much from this person. Otherwise, it will distort the entire picture.
Okay.
So, that's it. Thank you very much.
Okay. So, Amitji, whether the search person is entitled to copy of statement recorded during the search, this is a question which is pertaining and which is hovering around with all laws. Every time there's a dispute, what is the legal position in this?
Sir, to my mind, the statement should be, there is no restriction on not giving the copy of the statement. However, the legal situation is that whenever you go to the court for the copy of the statement at the investigation stage, the answer is that the investigation is going on. It is going to interfere with the investigation if we give a copy of the statement. And therefore, till the investigation is concluded, the copies are normally not given. So that is the position, in fact. And as the law stands, one cannot legally demand the copy. However, one should demand whenever the statement is recorded. When you are signing, you must say that, sir, kindly give me a copy. Whatever you have recorded, I cannot remember whatever you have recorded. So kindly give me a copy. At least you must demand.
Okay, Amitji, one more question in this. When you are under fear, under force, under different pressure, and the officer dictate the statement, and you are dictating your writing, what are the process at that particular time? Should you write in your way or should you write the way the officer is dictating?
Just give me a few minutes to answer this question. See, the statements, I'll not go into the sections and all that. Statements are primarily of two types. One given to the police, the other given to the all these authorities who are not treated as police officers under the law. As I said in the beginning, only CBI officers and the police officers are treated as officers, as police officers. All other officers under the SFIO, ED, income tax officers, they are all under customs laws, GST laws, they are all treated as not as police officers. So while the statements given to police are not admissible in evidence per se, the statements given to these officers or who are not treated as police officers are considered as admissible in evidence, because all these officers have power to record a statement on oath. So an oath is administered to you before they start recording the statement. Now, one has to also understand that there is a difference between admissibility and the evidentiary value of the statement. While these statements may be admissible in evidence straight away, however, these statements, the evidentiary value will depend upon many factors. For example, a statement is taken by somebody that I am the owner of Taj Mahal. Now that statement cannot be relied upon. Okay. It is per se a false statement. So even if it is given to a police officer, a non-police officer, or an ED officer, or a SFIO officer, it is contradictory, it is conflicting with the truth. And therefore, this statement will have no evidentiary value. Then law requires that all these statements, because these officers are supposed to be recording these statements as if they are a civil court. So the law calls upon them and law expects them to be fair. The statement ought to be recorded without any force or pressure or any kind of compulsion or any kind of dictation. So the moment it is shown that any kind of external force, coercion, any kind of temptation, anything which was exercised in recording that statement becomes invalid. That statement will have no evidentiary value, while it will become admissible in evidence. So now I come to answer your question, that the moment there is any kind of coercion or pressure, the statement is no statement. So one has to be very careful that about 1.5 year ago, the Supreme Court actually said that you ought to have cameras installed in the offices of all these agencies. And when they are investigating, when they are recording statements, they ought to be recorded on video. It cannot be just that they do anything with the person and record the statement. So the statement, when it is being recorded, it has to be your statement. Again, I would say that most people go with a preset mindset that the officers will be unreasonable with them. Let us presume that they will not be unreasonable with us. Let us behave as people who want to cooperate with the investigating agencies. Then what happens? That the officer will keep on talking to you. And then suddenly he will say, okay, I have recorded everything. Now it is all typed, you sign it. You are entitled to read the complete statement before signing now. And if there is something which you don't want to say, or even if you have earlier said so, you can always say that, no, sir, this is not what I meant. I wanted to say this. And you are entitled for correction in that statement. Of course, if any kind of force or pressure is used, then in that case, there are other remedies like retraction in the law. Those have to be resorted to. We will come to retraction a little later.
With that, I'll come.
Yes.
That I'll ask you later on.
Yeah.
Okay, Ravi, what is the scenario in SEBI and company law regarding to statement recording and
Very good.
taking copies?
Very good evening, sir. First of all, I must express my thanks to Khemka sir and Ashwani sir. And I sincerely believe that I would be better served by listening to them very carefully rather than speaking. Since you have asked, the position in law remains the same because, as I told you, the directive is from courts that so far as the investigation is continuing, divulging the statements and the investigative material would actually deter the investigation or might prove counterproductive to the investigation. An important aspect has been highlighted by Ashwani sir as well as Khemka sir, that one must not go with any preconceived mind or notion that a particular behavior would be rendered to them. Rather, one should not create a hostility merely because of preconceived notions. Rather, cooperate. Now, as far as the statements are concerned, what can be stated by a person? Not all the persons who are called by these agencies are experts. They are lay persons. In most of the cases, there would be lay persons as well. Maybe businessmen or involved in some trade or profession, but they might not be expected to have knowledge of law. So they can be asked questions in factual context. One is not responsible or bound under law to express opinions on legal positions or query the information pertaining to third parties. So therefore, this position is also, and I hope this still remains universal across the board, that one can only be asked information pertaining to oneself or of the business or of the affair of which one is in control, or about the facts that or information that one possesses or have reasonable access to. Third-party information, any comment, any opinion on third-party information is not something which one is expected to give, and this is not a duty under law. So the situation remains same in SEBI as well, sir, that during the investigation, they don't provide copies of statements, and one is not even legally entitled to, but as Khemka sir told, that one must always endeavor to reason out and ask the authorities that why you should provide us this statement.
Okay. Ashwani bhai,
Let me just add.
Yeah.
Actually, Ravi ji came out with something very important. You know, it is no guarantee that you have not done anything. In most cases, where blunders happen in giving statements, is where people come to us, especially very senior professionals, believing that whatever they did was perfectly within the four corners of law. And it is why, because they are the experts of that particular field. They know everything about that field. And then they believe and honestly believe that they have not done anything wrong. Let me say, sir, the guarantee that you will not be in trouble is what you say and not what you did. So it is necessary that you must articulate things while giving that statement. You may not have done anything wrong. And what is that articulation? The articulation is that you must present it not as the expert of the domain, but as a person who can put it simply. In that particular sense, that officer investigating as well as the judge who is going to be confronted with that statement tomorrow, they both are laymen. Let us understand that when they are talking about your expert, your domain, and that is something very important in case of professionals who are giving this statement, that when they are giving the statement, it should be in the simplest possible language. It should be in a way so that a common man can understand their domain, what they did as domain experts. This is very, very important, and thank you, Ravi, for coming out with this. Now, when it comes to the people who can't articulate, then they have also to be very, very simple. As Ravi said, that it should be only facts. They should only say, they should not try to justify their acts. They should not try to convince the officer that they have not done anything wrong. Just answer what he is asking you. He is asking you a simple question, answer that simple question. If that question comes out of a document, if the document is not in front of you, ask for that document. If the document is lying at your residence, tell him, I will come again, bring that document. But no answers either should be from the memory. Sometimes the questions asked are of 10 years ago. Why, even if you remember, you should not answer. You should not take that risk. You should first have the document in front of you. And the answer should be only to the facts, not argumentative at all, not trying to convince the authority that I have not done anything wrong. So this is, thank you, Ravi, for giving this and making me say that. Thank you.
Amitji, and I think Shuniji also, because we are on the statement. So first, any other message you want to give while recording a statement, what precautions should be taken, and then retrieval of the statement. What are the law behind this? So Ashwini, you have any point relating to this, what Amitji has told, Ravi has told? Any additional point relating to statement? What precaution you should take care?
In fact, with regard to statement, I would say it is art as well as science. Recording of statement, on the one hand, I have to fulfill the ability of a legally compliant and law-abiding citizen. On the other hand, I have to also ensure that I am not required to state the facts which are not known to me or which are not in my knowledge at that time when the statement is being recorded, or the facts are not in the manner in which the officer wants to write. but in the correct perspective only. When we record the statement, or when I give my statement, I'm not appearing for any exam. Please, the most of the stress while giving the statement is probably this belief that as if I have to appear in exam. So the moment this belief is removed, then automatically few problems are handled in a very, very natural manner. For example, first problem, memory problem. Now, for example, when I attempt in a question paper, I go with this expectation that everything will be in my memory. So I have to attempt. It is not required. Whatever can be humanly possible to remain in a memory, only that is. Second thing, it is not necessary to attempt all questions. You have to attempt only that question, the answer of which is in your knowledge or which is expected to be in your knowledge. Both the things are important. Something which is not expected to be in your knowledge, please do not attempt that. Something which is expected to be in your knowledge and in your knowledge, only attempt that. Because it is possible at that time, something is expected to be knowledge, but you are forgetting about it. There's no need. So the entire exercise of recording the statement is to not justifications or explanation. Please, it is not a reply. It is not a written submission. Not at all. It is just giving of the facts which are in your knowledge. That's all. So answer should be drafted in that manner only. If you do not agree with something, you have to say, no, I don't agree. Why you don't agree? It's not necessary to give opinions. So detailed justifications, detailed opinion formations can follow in the written explanations. There, my role, my responsibility as a search person or as a noticee is only confined to the aspect that the fact which is known to me, I will put forth.
Okay. Actually, you need to know basis. This
Need
is
to.
another word. Need to know. What does this mean?
ये तो लाइफ में पवन सर आप हमसे बेहतर जानते हैं कि ये जो एक्सेस ज्ञान है ना, ये हमें ज्यादा परेशान करता है. We have collected lot of information which is irrelevant. It troubles me in life. It troubles me especially at the time of recording of statement. So something which is relevant should be known to me. Put forth that only. Irrelevant things which I picked up on my casual observations or hearsay or my personal knowledge or discretions. No, it's no scope. Suppose he is asking, okay, in the year 2015, how much turnover of your business was? It is a matter of record. Something which is a matter of record, you can simply make compliance of the law by saying, yes, it was there, turnover was done. This much I remember. How much it was? I will check the balance sheet and will tell you. I will bring the balance sheet or you can download. If he asks how much profit was there, okay, even if you remember turnover, it's not necessary. How much stock, what was the quantity? I mean, I'm just giving these examples to make myself clear. So those facts which are matter of record, please do not join the issue at all. Suppose he says something on which you don't agree. Simply say, sorry, sir, it is incorrect.
Okay. Ashwini ji and Amit ji, now, what is the law relating to retrieval of the statement?
Retraction, probably you mean.
Yes.
Retraction.
Sir, retraction should be natural. That is one sentence which I'll elaborate upon. Now, what is natural? If a person was beaten for extraction of a statement, what would he do? Suppose it was not a police officer, or suppose it was not a ED officer, or it was not a SFIO. Suppose it was someone else, some common man, who had beaten a person and extracted a statement or extracted some property out of it. What would he do? He would go to some law enforcing agency. he would say that, sir, this has been done with me, which is illegal. Because forcing somebody to give a statement is illegal. It is criminal. So if this officer is committing a criminal act, the minimum which should be done is to complain to his officer, his seniors. If not going to the police, the one may not have the guts to report it to the police, but one can certainly write a letter or an email to the senior of this officer saying, sir, this person extracted this statement of mine by putting what kind of pressure or what kind of force. Now, this pressure, coercion, or force may differ from case to case. In somebody's case, just making him sit on the floor may be enough. In someone's case, having knee problem, making him do the sit-ups could be enough. In another person's case, few abuses may be enough. So in each and every case, the natural would be that this person actually specifies as to how and in what manner that coercion happened and how it is specific to his case. He will have to say that, sir, I have a knee problem and he made me do the sit-ups. Or I'm a respectable man, while all 5 officers were sitting on the chairs, or all other people who were being interrogated were sitting on chairs, they made me sit on the floor, and which was very embarrassing for me. And I told them that, okay, whatever you want, but don't insult me like this. So the retraction should be that of that person. It should not be an engineered retraction. It should not be a legally drafted retraction. It should be his retraction. That is again natural. Then what would be natural? If something has been done, there would be a sense of urgency in complaint. So the time lag in case of retraction is very important. If a person is retracting after 5 days, or if a person is retracting after 5 months, the seriousness attached by the law to that retraction would differ. And he will have to explain as to why he is doing it after 4 months, or why he is doing it after 4 days. Then that again is natural to explain. Suppose he was so sick, suppose he was hospitalized after coming out of the office of the concerned officer. So if he is giving a retraction after 5 days of coming out of the hospital or recouping himself, then it would be a natural delay. So even that delay ought to be natural only. So the keyword which I gave was that the retraction ought to be natural. Retraction should not be made up. Suppose somebody has some injury, even as bruises, he must go to the doctor. Not necessarily that he must go to a government hospital. Not necessarily he must go to some police station. Not necessary that he must get a medical legal report done. He can go to any hospital and ask them that, sir, this is what has happened with me. Kindly treat me. And let the doctor write. Take photographs of the injury if possible. Get all the examinations done. Suppose in one of the cases, a person was hospitalized during the search. No, he ought to, he almost had a heart attack.
Okay.
So all these things are important, sir, that circumstances which will show the use of force or use of coercion or use of any extraneous circumstance that would be relevant for deciding the ultimate evidentiary value of the statement recorded by the officer, which is, as I said, admissible in evidence per se.
Okay. Amitji, I have various questions. Now time is less, so we have now rapid round. Okay. So please, all the speakers, please give answer on very short answer, so we can cover maximum question. What are the consequences of retraction, Ashwini bhai?
In fact, the consequences as far as the person is concerned, or I would say the benefit who is retracting, is that he will not be, if the retraction is valid, he will not be bound by the statement so recorded.
Okay.
He finds it is illegally. But
okay,
if retraction is invalid, so his investigation will get further intensified. Yes.
Okay. Whether the statement recorded under these act admissible in evidence?
I told you that except the statements given to CBI and police, all these statements are admissible in evidence.
Okay. Suppose some officers are doing misbehave and other things, and what are the legal remedies available in case of misbehave or assault by any officials? And another aspect is whether that statement will be valid or not.
So, as I said, that one can go to police, one can make a police report. There is nothing stopping. One can go to the High Court, filing a writ petition for further directions in the case. There are so many remedies available. If suppose somebody has been hurt, somebody has been beaten, then he can, with the medical evidence, he can go to the High Court and say that from next date onwards, my lawyer should be allowed to be present, or my statement should only be recorded under camera. So all these remedies are available. And of course, that statement will lose much of its evidentiary value, even if it is admissible in evidence.
Okay. Ravi, what is the effect of a statement and confession of co-accused?
That is corroborative in one word. It cannot be the sole evidence on which prosecution can stand. That is
Okay.
only corroborative.
Okay. Can a statement recorded by one authority used by other authority also?
Yes, because sorry, sir.
Please carry on.
Please carry on, Ravi.
I'm so sorry I took it up out of the turn.
Yeah, it must.
But because if the nature of statements as told by Taneja sir and Khemka sir are statement of facts. So if these are not retracted, if they contain some skewed information, it may hurt you if it is used by authorities. And there are interdepartmental cooperation between agencies, so they can be very well relied upon by other authorities. But then they have to independently do their own examination and investigation. They can't just merely rely on it. So you may take it.
I will say two things here. First of all, if a statement is an admissible piece of evidence, keeping with all the facts and circumstances, it is an admissible piece of evidence. But the only factor which I would add here is, suppose a statement is recorded in a particular context, keeping with the objective of a particular law, then if any other agency is using it. So, I mean, that factor has to be kept in mind, that further corroboration may be required by the other agency. It can be point of initiation of the fresh investigation, and it could not be a conclusive evidence there with the other agency. Thank you.
Okay. Ashwini ji, implication of admission of or concession made while giving a statement under PMLA under Section 50 of PBPT Act under Section 19.
सर हम इसको ना कभी-कभी को कहता है सरेंडर कर दूं, तो हमारे मुंह से एक ही बात निकलती है, अच्छा तुम कह रहे हो बवंडर कर दूं. एक्चुअली सर इसको इस तरह से कह सकता हूं मैं, एक इंसान का, आदमी का, पुरुष के जो सबसे बड़ा शत्रु है वो कौन है, अगर पहली बात ध्यान आती है तो एक ही आती है कि वो स्वयं. तो वो खुद ही अगर कोई चीज एडमिट कर लेगा, चाहे वो रॉन्गली एडमिट कर लेगा, तो एंटायर बर्डन विल बी शिफ्टेड अपॉन हिम टू लेटर ऑन शो दैट दिस इज नॉट द फैक्चुअल सिचुएशन. So by admission, whatever consequences are there that are bound to follow. 1, 2, if admission has been made for a particular thing, say for tax evasion, say he concealed some income. So to that extent, it gets admitted, though other consequences will not happen. He cannot say that it was for this limited purpose of tax offer. Suppose it is then proved under Benami also, it is proved under money laundering also. So that consequences might also take place while making any admission. He has to keep this thing in mind. So totality of the responsibility has to assume.
So just
Okay.
one more sentence, sir. Before any kind of compounding in any other law or any kind of surrender, it is necessary as on date to see or examine the implication of that compounding and surrender under all these economic laws. It cannot be just narrow approach of looking at that particular act and just barging into compounding or barging into surrender. So it has to be very, very clear that there could be implications of any kind of compounding or any kind of surrender in other laws, and which may be more serious than even that particular act.
Okay, like latest is going on the SEBI settlement scheme, where when you say that this transaction I have done, so that is okay. The SEBI penalty is 1 lakh rupees, but PMLA income tax is also there. They
Yes.
can also see that you have done the wrongful
So
transaction.
that comes
Sir,
with
even-
the list of scheduled offenses.
Yes,
Even
that's right.
insider trading under SEBI is a scheduled offense under PMLA.
Yes,
So one may think that by paying the penalty, I have it is all over,
Got rid of
everything.
yes,
So SEBI is not launching the prosecution after you pay the penalty, but
yes.
then ED might launch the prosecution.
Okay, Amiji, now very interesting point which I am starting with you. Burden of proof. Now it is different in all types of all laws. So please explain burden of proof. What is burden of proof? Number 1, and what is reverse burden of proceed? How the reverse burden of proof, and at what state the proceeding of burden of reverse. So all these things, if you Mamitji and Amiji, Shuniji and Ravi, you can just tell, it will be very useful for all the people.
Sir, under the normal criminal law, IPC offenses, the whole burden to prove is on the prosecution. The prosecution has to prove the offense 100%. There is, even an iota of doubt can result in acquittal of the person. When it comes to offenses under PBPT, there also the situation remains same. There is no burden, no reverse burden there. But when it comes to even in Companies Act, there is no reverse burden under 447 and all. The reverse burden is present in the case of Black Money Act, in the case of Income Tax Act, and in the case of PMLA. Now, in the offenses which require a mental faculty under the Income Tax Act or under the Black Money Act, which say, the most commonly used word there is willful evasion of tax, willful evasion of payment of tax, or willful non-disclosure, or willfully giving a wrong statement. Now, all those, wherever that willfulness or mental faculty is required, whether under the Income Tax Act or under the Black Money Act, the burden is reverse. So far as the factual part is concerned, the onus is on the prosecution. However, there is a presumption of mental faculty in case of Black Money Act and Income Tax Act in respect of certain offenses.
Okay,
In
yeah.
prevention of money laundering, Ashwini Taneja ji can do so far as PMLA is concerned.
Yeah, Ashwini bhai.
Actually, what I see in the entire litigation going on in the country, this entire litigation hinges on the concept and game of burden of proof. If burden is upon whether on the prosecution or upon the accused, noticee or the officer giving the notice, and it hinges like pendulum on like this. So burden discharged properly, burden comes back to prosecution. Prosecution discharges the burden, it comes to the notice. Now, our constitution is based upon the principle that the burden is upon the person who is accusing a person to be guilty. Otherwise, a person is presumed to be innocent. So, who is alleging, he has to prove. But the only compromise, major compromise has been made with this concept of the constitution. Any constitutional fabric, if it is being pierced, it is a major thing, it's not a smaller thing, is under section 24 of PMLA. But the only difficulty which has arisen, because of which people are feeling difficulties, the erroneous understanding about the shifting of burden. Because according to my considered opinion, shifting of burden is very part. For example, there are 3 facets in money laundering. One is commission of scheduled offense, other is generation of proceeds of crime, and third is offense of money laundering by converting that money into good money. Now, burden has been shifted upon the accused with regard to the third thing only. So, crime has been committed and proceeds therefrom has been earned. This burden still remains on the prosecution. And because of this misunderstanding, the whole ruckus is happening. And on the part of the people also, they are not understanding that once the burden is shifted, it is now their duty to discharge. While filing reply, while giving statements, they have to follow the law. Thank you very much.
Okay, Ravi, what is your view on the SEBI and Companies Act relating to burden of proof?
Well, burden of proof is not a statutory scheme in SEBI laws usually, but it got developed due to precedents of Supreme Court, particularly the precedent of 2017 in Kishore R. Ajmera's case. But the Supreme Court has revisited this situation in the famous case of Balram Garg, which is also known as PC Jewelers case. And they have said that although you can use preponderance of probabilities, they have said you can't use it arbitrarily. There has to be a scientific method. There has to be a methodological process of contriving the chain of events. Today, in hindsight, you look at things in a different way, contrive a chain of events which is entirely skewed and portrays a distorted picture. So therefore, it also affects the reliability, which is the outcome, and the fairness and accountability that is concerned with the process, how you adjudicate. So therefore, the question is still to be answered by Sir, at what stage it will kick in. And that is the most interesting part. But the reverse burden of proof is antithetical to the common practice, as both Sir have told us. So therefore, it comes in play in specific circumstances, and its interplay also is limited and safeguarded by the jurisprudential principles of law. I would request Sir to clarify on at what stage it kicks in.
Okay, Ravi, Amitji, you want to add something or
this? Very aptly presented by him. There is, we have to be, as Ashwini ji said, that there are certain foundational facts. Those foundational facts need to be proved by the prosecution in all cases, irrespective of reverse burden. It is not that you just say that you have committed this crime and thereafter the respondent will start answering everything. It's not like that. So there have to be foundational facts even in those cases where partial reverse burden is on the accused. However, after those foundational facts have been set up and established by the prosecution agencies, then only the question of reverse burden or proving the reverse will arise. The presumption cannot kick in on the allegation of the officer concerned. So it is as simple as that. Prove your foundational facts. Supreme Court in Vijay Madan Lal just now has said so, that foundational facts have to be proved first. You cannot just make an allegation and thereafter start asking the person that now you prove everything negative. So it's not like that. Law is not that truncated as yet.
And special court recently in a judgment, special court in Mumbai, in the bail order itself, while granting the bail, has said that the foundational fact has to be proved by the enforcement directorate.
Absolutely.
And only the burden will shift.
Okay. Amitji, recently Supreme Court has given instructed that video recording for a statement. So there are two questions: whether this is happening, or how this will take shape, or is it applicable to such proceedings also?
See, sir, normally the courts give a little loose rope to the investigating agencies. Let us understand it's not easy to investigate. Somebody, especially in the case of white-collar crime, these things are done, as I said, behind closed doors. The conspiracies are hatched. People involved are very, very intelligent and capable people. They are not some kind of, illiterate or those kind of persons. So it is not easy for all these investigating agencies to be investigating and finding evidence, because these people are also experts on erasing or concealing evidence. Therefore, the courts have an attitude of giving a loose rope to these agencies. And that is why the courts are always hesitant in laying down any tight or any strict rules of investigation. They always say that it has to be from case to case basis. And let me also tell you that it is not that in every case the agencies are doing something wrong, or they are crossing their limits. In some cases, they do under some kind of a temptation, they might be doing that. So courts don't really lay down all these procedures, and therefore these agencies ought to be given a little loose rope, and we have to believe them, we have to trust them. Otherwise, the system will not be able to work. After all, they are working for our benefit only, for our good only.
Okay. Now, there is a very interesting point, which I just want to understand. The balance. Now, what is happening in Indian regime? How the balance is struck between necessity to investigate and defense to individuals' privacy. Ravi, you start, because this question has come through and then I will ask Amitji and Ravi.
Necessity to investigate represents
Ravi.
and find. Yes, am I audible, sir?
Yes,
very much.
So the necessity to investigate is the necessity. Now we can understand the significance of the context from the importance of detecting the crimes and bringing it to the law. Deference to privacy of citizens is also equally compelling interest. But there are certain parameters when these two collide with each other. It is not necessary that we see it in the gamut of collision or they overreach each other. They can be harmonized to a large extent. And this is why in their discourse and deliberations, both Khemka sir and Ashwani Taneja sir has told us what are the safeguards available with people to protect their privacy while also assisting the agencies in doing their work. Because the bias of investigators by far theoretically recorded most gravest kind of bias, because when they come to investigate, they always had a surveillance, which is a precursor to investigation or some kind of inspection. So therefore, they are coming to investigate to find something, to unveil the truth. But then the bias chips in. Bias that where we are going, we are definitely going to find something untoward or something unlawful. But therefore, in this situation, the prime responsibility, and I'm just repeating myself, I'm just repeating what they both have said. The prime responsibility rests on the person, their knowledge, their awareness as to how how innocuously they can protect their privacy. And certainly, when they visit you at your residence or office, you cannot argue with them. It has to be very hospitable interaction. Hostility would mar it.
You should not argue with them.
You should not argue with them.
Okay.
Yes, sir.
Okay. Amitji, your point.
Sir, it's very simple. The privacy is yours. First of all, you should safeguard that privacy in the normal course also. You know, your office computer should not have something private. You know, so it is something like this. However, that was in the lighter mode. One can, suppose your computer has something private, or suppose your mobile has something private. I told you that you can say that, sir, please steal it. Because whatever information you need, only that part of information should be taken from here. Not a phishing inquiry. Not an inquiry into my private affairs. And if they don't agree on that, I have given you the answer, call 100 number. And there is no doubt that every investigation will actually transgress on your privacy. After all, even entering into your house is transgressing your privacy. Entering into your office in the presence of your subordinates, in the presence of your clients, that is transgressing your privacy. Actually, it is humiliating. But then the law it is required. If those powers are not there, no investigation can take place. So that is why law draws a balance. In case of Mahmood Pracha, as I gave you the example, he went and he said that no, they cannot go ahead. In case of SR Bartley Boy, they went to the court and court protected them. The only thing the court is not doing is to lay down any fixed guidelines for doing that. But the courts are there to protect your interest, provided there is a reasonable case for that.
Okay. Okay. There's a
I will conclude this, in fact, by taking a question which is there on the question answer column. If you will kindly permit me, I will aptly summarize the situation which is being debated here. Am I permitted to do that, sir?
Yeah, please.
Mr. Girish Gakhar has asked a question. When the abuse of law by a citizen is justified, then the abuse of humanity interrogation is also justified. It's a very good question, in fact. 2-3 things I will mention in response to that. First of all, when the interrogation is happening or investigation is happening, it is not yet proved that there is an abuse of law. They are just investigating it. So therefore, they do not get the right that since a person has abused the law, so therefore we will abuse the immunity. Very, very, very unfair. A. B is very, very important, that a private litigant and the state, they are two different things. State officers have the might of the state. They cannot behave like a private citizen. They are upholding the sovereignty of the country, the grace, our constitutional. They cannot become disgraceful, neither to themselves or to the society or to anybody else. So therefore, please remove this thought. In my considered opinion, I have also been a government officer. The government officers should behave in a most constitutional, legal, human manner. Thank you very much.
Okay. Amitji, one question.
Equity is the key.
Equitable manner.
Equitable manner. Everybody has to work in an equitable manner. You as well as the officer. It's as simple. And
Amitji,
sir,
Amitji,
let me answer the question of Mr. Vinod Mohan.
yeah,
So he says that suppose no written notice has been received from the authority, then also are we supposed to be present? The answer would be no. However, the practicality does not demand that. In a practical situation, you will have the fear and you will actually be annoying this officer. So what would I do? I would send an email to him that, sir, you asked me to come on Tuesday. Tuesday, I have some private work. Can I come on Wednesday? He will have to answer. So you have put it on record. You must not go there without putting it on record. That is more important. Question is not that whether you should go or not. You should go. But you must put it on record that you went. And when you go, try to make an entry in the entry register. Try to have a copy of the pass clicked on your mobile and sent as a WhatsApp to your friend of yours, so that there is evidence of the fact that you attended the office.
okay.
This is how I would like to put, and then it also some more things come to me. Now, we have seen that as soon as a summons comes, suppose it is for production of certain documents, most clients will be, they would say, oh, he has asked us to give it by 21st of December, or 21st of this month. We must give it. No, sir. You must give it only when they are ready. Suppose you need more time, you must ask for more time. Suppose you are not in a position to go, send it through an authorized representative. The law allows you to do that. Suppose he has called you for a statement. You have some very important business to do on that day. At least you have a right to ask him that, sir, I have some other business to predetermined business to do. Can I come the next day? Can I come after 4 days? Can I come after 3 days? So there is nothing कि सम्मन आ गया तो उसके बाद में हमने कुछ और करना ही नहीं है, बस सतर होके खड़ा हो जाना है. No, you have to take your time. You have to be, it's not that must cooperate, but at the same time you have certain liberties and certain rights. That is what I wanted to say.
Okay. So now all our learned speaker has given the various legal facets of this complicated, very cumbersome, fearful, and sometimes it's a very consequential to your dignity, to your work, to your future life. So they have explained and they have given the solution also, that what you should do legally. Everybody should understand that investigation is a process where you have to cooperate. Simultaneously, you have a right also to protect your right also. So all three speakers very lucidly given you the solution of all points. In case any issue is not answered, you please write to us. We will take the help of our learned speaker and send it to you. Now, as our ritual, we are asking everyone that what is the, in this country, in 1 minute you have to tell about this topic, what should be the right scenario where the authority, looseness of strictness and sometimes beyond the law, over enthusiastic way, where court is also coming heavily on them. Sometimes people are doing mistake which is very silly. So what is your solution to face this particular challenge, and what are the changes you think should be there in the law so it can protect the privacy as well as the individual's right in the right respect which Constitution provides? I will start with Amitji.
Sir, so far as the agencies are concerned, equity, fair play, and they must understand that any wrong action by them is going to be injurious to the economy of the country. They have the responsibility, they have been given all these powers in order that the economy of this country works properly. The crime money doesn't come in, people don't evade taxes. That is the whole purpose. So any wrong act is as counterproductive as your right acts would be. And so far as the people are concerned, it is the duty of the common man to presume that these officers are working fairly and give them complete cooperation and give them complete respect for the work which they are doing. It's a cumbersome job. It's a difficult job to investigate. It's not easy. So we must cooperate with them. It is only when the officer does not behave, if he has some bias or some ulterior motive, then the law is there to protect.
Thank you. Ashwini.
I would say it like that. Every officer has been assigned a role within the constitutional and legal framework and the statutory framework. So one must perform his role diligently and aptly. Meaning thereby neither he should underdo or overdo his role, A. B. She should not endeavor to perform the role of somebody else. Only these two things. Automatically, everything which Khemka ji is saying will happen.
Okay, Ravi.
And as far as citizens are concerned, two responsibilities. They must comply with the law. They should maintain the grace for our country, A. B, they should have sufficient material evidences in their possession that whenever asked, they can show, demonstrate, prove that they have complied with the law. That's it. Thank you very much. Yes, sir.
Yes, Ravi.
Yes, sir. So I have the benefit of views of both of you. So I would say it in a way that sums it up or brings what you have said together. The investigative agencies as well as the judicial institutions, they are held accountable through transparency and not by opaqueness. Because opaqueness furthers a culture of impunity, bias, and both sides have told us aspects and elements of how it can be antithetical to the cherished value of this country and our constitutional principles. So therefore, transparency should be furthered and opaqueness should be curtailed. And this should be done continuously and should be monitored throughout. That is what I understand from the message given by sirs.
Wonderful.
Thank you. Thank you very much, Ashwini ji, Amit ji, and Ravi. Very nicely concluded this point. And that is also absolutely right. When the Supreme Court and the other court has given instruction, then the authority should follow. Simultaneously, the citizen should also realize, the corporate should also realize, if there is something wrong, that's why they have come. Some clue they got, that's why they have reached to you. They are not coming just for the sake without any point. And if they are coming out to you, then they have to prove in the court and they are the side of the government. So they are also bound to take the court is also coming very heavily on these people also if they are coming out without any preparation and without any substance. So let's hope the country will see and the Supreme Court and other people, they will work out, because I was reading the Supreme Court is talking about in what case you should give capital punishment and they want to make a rule and law. So by doing this, all these courts will follow. The Supreme Court say bail, not the jail, is the constitutional right of the citizen. But we have seen that all courts are following a different path and people are suffering. So if the court and Supreme Court can come out and they can give a clear direction to make the system more transparent, it will be good for the country. It will be good for the wrongdoer also, that they will have a right fear and we will not waste time on all these unnecessary things. Thank you very much. Thank you. This was a topic which so many people were asking, and we have tried to give answer of all things. Friends, this journey of knowledge will continue. And today, the three speakers has given their time. So thank you, Amitji. Thank you, Ravi. Thank you, Ashwini-ji, for contributing very prominently and very effectively. Thanks on behalf of everybody. And thanks all participants. Friends, our journey of this knowledge sharing will continue. And we are reaching shortly on our 100th webinar. So before that, the date of 100th webinar, we will inform you. But next Friday at 4 to 6, we are having a very interesting topic and very topical issue, the reclassification of promoter. As per SEBI law, the once promoter, at old SEBI law, once promoter is always promoter. But after that, Companies Act and SEBI has changed so many things. But it's still, the reclassification of promoter is a very cumbersome process, very complicated process, and it's require a clear and clean law for everybody who is not a promoter now. He should be, because the consequence of being promoter in a company is very tough. They can freeze your account, they can take action against the violation of other promoter. And if you are not managing and controlling and not the promoter, then you should have a right to reclassification. So the process of complete reclassification, we will discuss next webinar on Friday and 30th. Until then, thank you all. Thank you, my all participants and learned speaker. Thank you very much.